welcome to The Firm. It's a different show this week, more intense, more analytical and more international. So buckle down for here's what's coming up in the next half hour. Welcome back. This is The Firm. How ironic. In the last month, as Wall Street was grappling with the consequences of too much risk, too much greed and too little scrutiny, another instance of such excess reached a historic conclusion. The 7-year-old Enron shareholder battle won a record $7 billion compensation. Now that's the beauty of the American legal system. Intended fraud or unintended failure, it's always penalized. An accounting scandal, corporate fraud, $16 billion in debt and finally Chapter 11 bankruptcy. The decline and fall of American energy giant Enron in 2001 wiped out more than $60 billion of market value, cost 4,000 people their jobs and left behind thousands of shocked shareholders. Shareholders who after 7 years of court battles have finally got their dues, at least some of them.
Well, there are two aspects of American law that are very beneficial to investors recovering from those who commit fraud. One is that the securities laws in the United States are very investor-friendly and very much designed to give investors remedies when fraud takes place. The other is that the United States has a class action mechanism which allows thousands of investors to come together in the same lawsuit and pursue their claims together and hire counsel who work on a wholly contingent basis and get paid out of any recovery at the end of the case.
As a result of these class action suits, on September 9, 2008, the District Court of California ordered Citigroup, the Canadian Imperial Bank of Commerce and JP Morgan Chase to pay Enron investors $6.6 billion. The banks were accused of aiding and abetting Enron's fraud. Bank of America and Lehman Brothers, along with erstwhile accounting firm Arthur Andersen, law firm Kirkland & Ellis, had to cough up $500 million. And former Enron directors settled for a total $168 million.
Well, a shareholder can bring a suit against anyone who was responsible for the fraud. In the case of Enron, where the company had gone bankrupt, a lot of the claims were brought against outside parties, such as banks and professionals. And those were based on claims that they had facilitated the fraud or helped to make it possible. And you see that frequently in these types of cases where the primary defendant doesn't have the assets to pay a judgment. Plaintiffs will go after other defendants who are perceived to have deep pockets and greater assets.
Deeper pockets that will now shell out up to $7.2 billion, the largest investor payout ever in the history of the United States, to be split between 1.5 million individuals and entities that once held the Enron stock. Now that would never happen in India. Isha Dalal finds out why.
Well, let's first look at director and management liability. According to the Companies Act, neither the directors nor the company are directly liable to shareholders in the event of mismanagement, fraud or failure.
There aren't sort of provisions which specifically provide for any liability that the company is going to have or directors are going to have directly to shareholders. There are provisions which provide for certain fines to be levied on companies for failure to, adhere to regulations and things like that, to failure to adhere to corporate governance standards. But those are sort of regulatory fines that money doesn't really find its way into the shareholders' pockets.
Measly fines at that. So let's say you're a director of a company that's found guilty of improperly issuing, circulating or publishing financials. The fine? A princely sum of 500 rupees. It's the same for not complying with proper procedure in the appointment of auditors or management of accounts. And if the company has withheld disclosures, it's 10 times more at 5,000 rupees. So, can directors just get away with minor penalties? Well, not quite. Experts say there's nothing that stops a shareholder from initiating action against the director or the company itself.
There are regulations where you find, say, if there is insider trading by a company, and when that insider trading benefits are taken, or if the situation where directors who are in a fiduciary position are found to have siphoned off money, then investors can get back into effectively getting the monies back from those directors. Or if there is a kind of mismanagement, or if there is a question of falsification of accounts in presentation. So all these cases are there in our machinery.
Except that they've never been used. So under Section 235, if an application for investigation is made by 200 shareholders or those holding at least 1/10 of the company's voting power, or at least 1/5 of the people on the company's register of members, then the central government does have the right to investigate the affairs of the company. And of course, under Section 397 and 398, shareholders can approach the Company Law Board or CLB with allegations of oppression and mismanagement. But it's not an easy case to make without regulatory or state investigation to establish wrongdoing.
397, 398 are more for private companies where there are two partners or two group of shareholders who know everything about the company and they can show that really there was a mismanagement. But in the case of a layman shareholder, I am say 1000 shares or 500 shares, I don't know detailed how the company is mismanaged.
And experts can't recall a single case in which shareholders have even asked to be compensated.
At the most I can say that whatever has been siphoned off, whatever has been mismanaged, those funds you should give it back to the company. But there are very few, I have not heard any case where they have said please give it to me individually or give it to us individually. That I think not a plea has been made as of now.
But let's suppose for a moment that such a suit is filed and is successful. Will investors get their money back then? Well, if the company hasn't liquidated yet, then there aren't any provisions in the law and the awards are at the discretion of the courts. And if the company is already bankrupt, then it's nearly impossible for investors to claim their dues. Because according to Section 529A of the Companies Act, there's a payback hierarchy for funds recovered from the liquidation of a bankrupt company. Shareholders rank last on that list. But what happens to the liquidation proceeds if shareholders have won a payout through a class action suit?
Do they go directly to those shareholders who've done the class action or who've sued these fiduciaries, or should they be going into the kitty of the liquidation proceeds and to then be paid out as per the kitty is an open question. To my mind, if it is a private party litigation where there is a class action and a group of shareholders, then the money should technically go to the shareholders because it's those shareholders who are alleging and praying that they've been defrauded and so on. But under company law, again, the company court could take a view and the creditors could take a view that this is actually money which is belonging to the common kitty and then should go as per the Companies Act on winding up payouts.
So what does all this mean? Well, if you're a defrauded investor in India, there's almost no chance you'll get your money back. The laws exist, but they don't seem to work very well. And of course, shareholders are hoping they never have a reason to put these provisions to the test. In Mumbai, Isha Dalal.
All right, with that, it's a wrap on this edition of The Firm. We're so completely out of time that here's a quick goodbye. See you next week.